and learn the Bare Act very easily with me. वेलकम एवरीवन, आपका मेरे चैनल पे स्वागत है। मैं आज एक नया बेयर एक्ट जो कि बेयर एक्ट है BSA यानी कि भारतीय साक्ष्य अधिनियम, इसको पढ़ने का शुरुआत करेंगे। इसमें ज़्यादा सेक्शंस नहीं हैं, लेकिन फिर भी हम कोशिश करेंगे कि इसको बहुत ही आसानी से और बहुत ही आराम से पढ़ें, बहुत इंटरेस्टिंग तरीके से पढ़ें, ताकि आप लोग सिर्फ सुने और आप लोगों को याद हो जाए। आपको स्क्रीन पे देखने की ज़रूरत भी नहीं है, सिर्फ आप ईयरफोन लगा के बैठिए, आपको सब याद हो जाएगा। सो बिना समय गवाए हम शुरुआत से शुरू करते हैं। तो लेट्स गो। भारतीय साक्ष्य अधिनियम 2023, an act to consolidate and to provide for general rules and principle of evidence for fair trial. These two are very important words. Principle of evidence for fair trial. Be it enacted by Parliament in the 74th year of the Republic of India as follows. Part 1, Chapter 1, Preliminary. Section 1, Short Title, Application and Commencement. Subsection 1. This act may be called the Bharatiya Sakshya Adhiniyam 2023. Subsection 2. It applies to all judicial proceedings in or before any court, including court-martial, but, here is the important point, but not to affidavit present in any court or officer, nor to proceeding before an arbitrator. These two are very important. मैं एक बार फिर से रिपीट कर देती हूँ. It applies to all judicial proceedings in or before any court, including court martials, लेकिन not to affidavit present to any court or officer or nor in arbitrator. Okay? Now, subsection 3. It shall come into force on such date as the central government may, by notification in the official gazette, appoints. Now, this is a very important section, section 2, that is definition clause. In this adhiniyam, unless the context otherwise required, A. Court includes all judges and magistrate and all person except, here is also exception, arbitrators legally authorized to take evidence. Arbitrators legally authorized to take evidence. B. Conclusive proof means when one fact is declared by this adhiniyam, when one fact is declared by this adhiniyam to be conclusive proof of another, the court shall, on proof of the one fact, regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. इसमें एक चीज़ बस याद रखने की ज़रूरत है. कंक्लूसिव प्रूफ में बोल रहा है कि अगर फैक्ट ए है जिसको सही मान लिया गया है, तो उससे फैक्ट बी को भी हम लोग सही मान लेंगे. यानी कि एक चीज़ अगर साबित हुई तो दूसरी अपने आप ही सच मान ली गई. इसमें रिब्यूटल्स नहीं होते हैं, इसके खिलाफ सबूत देने की इजाज़त नहीं होती है. शैल नॉट अलाउ एविडेंस टू बी गिवन फॉर द पर्पस ऑफ डिस्प्रूविंग इट. ओके, नाउ द नेक्स्ट इज डिस्प्रूव. In relation to a fact means when after considering the matters before it, the court either believes that it does not exist or consider its non-existence so probable that a prudent man ought, under the circumstances of a particular case, to act upon the supposition that it does not exist. D. Document means any matter expressed or described or otherwise recorded upon any substance by means of letter, figures or marks, or any other means, or by more than one of those means intended to be used or which may be used for the purpose of recording. that matters and includes electronic and digital records too. Now the illustration is here. A writing is a document, word printed, lithographed or photographed a document. A map or plan is a document. An inscription on a metal plate or stone is a document. A caricature is a document. An electronic record on email, server logs, documents on computer, laptop or smartphone, messages, website, location evidence, and voicemail messages stored on devices are all document. Now, evidence. Evidence means and includes 1. All statements, including statements given electronically, which the court permits or requires to be made before it by witnesses in relation to matter of fact under inquiry, and such statements are called oral evidence. 2. All documents requires electronic or digital record produced for the inspection of the court, and such documents are called documentary evidence. Now facts. Facts means and includes 1. Anything, state of things or relation of things capable of being perceived by the senses. 2. Any mental condition or which any person is conscious. Now there is the illustration. 1. That there are certain objects arranged in a certain order in a certain place is a fact. 2. That a person heard or saw something is a fact. That a person said certain word is a fact. Now 4. That a person holds a certain opinion. A certain opinion has a certain intention, acts in good faith or fraudulently, or uses a particular word in a particular sentence, or is or was at a specific time conscious of a particular sensation is a fact. थोड़ा सा कंफ्यूजिंग है, बट अगर आप इसी तरह से तोड़ के पढ़ेंगे तो बहुत ही आसानी से समझ में आ जाएगा. जी. Facts in issue means and includes any fact from which, either by itself or in connection with other facts, the existence, non-existence, nature or extent of any right, liability or disability asserted or denied in any suit or proceedings necessarily follows. सिर्फ यहाँ लिया है any suit or proceedings. Explanation. Whenever under the provision of the law for the time being in force relating to the civil procedure, any court records an issue of fact, the fact to be asserted or denied in the answer to such issue is a fact in issue. Now there is an illustration here. A is accused of murder of B. A is accused of murder of B. At his trial, the following facts may be in issue. First, that A caused B's death, correct. 2. That A intended to cause B's death, correct. C. That A had received grave and sudden provocation from B. D. That A, at the time of doing the act which causes B's death, was, by reason of unsoundness of mind, incapable of knowing its nature. Next, may presume. Whenever it is provided by this adheniyam that the court may presume a fact, it may either regard such facts as proved unless and until it is disproved, or may call for proof of it. Not proved. A fact is said to be not proved when it is neither proved nor disproved. यानी कि ये बिल्कुल ऐसा है, ना ही प्रूव हुआ है ना ही डिस्प्रूव हुआ है. Proved. A fact is said to be proved when After considering the matters before it, the court either believes it to be exist or consider its existence to probable that a prudent man ought, under the circumstances of the particular case, to act upon this superstition that it exists. Relevant. A fact is said to be relevant to another when it is connected with the other in any of the way referred to in the provision of this adheniyam relating to the relevancy of facts. Now, shall presume. Whenever it is directed by this adheniyam that the court shall presume a fact, it shall regard such fact as proved unless and until it is disproved. 2. Words and expression used herein and not defined but defined in the Information Technology Act. Let me repeat it. Words and expressions used herein and not defined but defined in IT Act 2000, the BNSS 2000 and the BSA 2023 shall have the same meaning as assigned to them in the said Act and Sahitas. So, this is the bare reading of section 1, 2. I hope you understood that और मैं आशा करती हूँ कि आपको बहुत ही आसानी से समझ में आ गया होगा. अगर आपको अच्छा लगा हो तो एक बार लाइक, शेयर और सब्सक्राइब ज़रूर कर दीजिएगा ताकि आगे लोगों तक पहुँच सके और वो भी इसे आराम से सुन के और समझ सके. और हाँ, जाते जाते घंटी ज़रूर मार देना ताकि आगे चल के अगर कोई भी ऐसा वीडियो आए तो आप उसे ध्यान से सुन और समझ सकें. ओके, हैव अ नाइस डे. बाय बाय.